Welcome to Chair Chat from the ABA section of Civil Rights and Social Justice. I'm Steve Wermiel. I'm a past chair of the section and honored to get the chance to do a guest hosting gig on this wonderful feature of the section. Our chair, Robin Runge, has decided to share this opportunity with past chairs, and it's a treat to be able to do this. I'm here with Professor Jeff Stone of the University of Chicago Law School. Jeff is with me because I think he is one of the, if not the leading free speech academic, theorist, writer, advocate, and teacher in the country, and has been for decades. Jeff has had a remarkable career after clerking for Justice William Brennan on the Supreme Court. He's been teaching at Chicago for decades. He was dean at the University of Chicago Law School for about 7 years, and then was provost of the University of Chicago for about 7 years. He has written, not counting law school case books, he's written about 8 or 9 different books, and many of them covering different facets of free speech and the history and the role of free speech in our society. And so Jeff is a perfect person, I think, to have a conversation with about the role of free speech in our world today, in our society today. So Jeff, welcome, and thank you for being here.
Thanks so much for inviting me, Steve.
I'd like to start with pretty much what the introduction suggested. I think we find today that free speech is not universally respected. There's probably a move in some circles, maybe younger generations, that don't understand the value of having to live with speech that they don't like or that they don't want to hear. And so let's start there. What is the importance of free speech in a democratic society today?
Well, the first and most important has to do with democracy, and the fact that we often think we know the answers to questions, but once we listen and hear and read, we change our minds. Recent examples of that would be, say, acceptance of gay relationships and gay people. 50 years ago, that would have been regarded as ridiculous. But today, a substantial majority of people regard gays and lesbians and so on as legitimate friends and neighbors and professors and students and so on, lawyers. And that's mainly because of free speech. It's mainly because people have been willing to listen and to learn. Same thing was true with the women's movement. Back before the late 1960s, most people did not think very much about women's rights. And then with the women's movement, and public attitudes changed dramatically. And so people have to understand that we learn from others, and things we believe to be true and correct and right may turn out not to be. And the way we learn that is by listening to people who disagree with us. Sometimes they may be wrong, often they may be wrong, whatever wrong means. But the truth is, if they weren't allowed to say what they want to say, then we would not have the opportunity to rethink our own beliefs over time. And so that's, I think, one of the most important aspects of free speech. And it has enormous role in democracy. In order to know what candidates to vote for and what laws should or should not be enacted, it's important to understand the wisdom and the correctness and the thoughtfulness of their positions. And the only way we get to do that is by hearing people advance their positions and criticize them. And that's the central part of what democracy is about. Free speech is also about self-fulfillment, that individuals have a natural need to say what they think. And if they were stifled from doing that, that would definitely harm their individuality and their integrity and their ability to be who they think they should be. And that's another rationale for protecting freedom of speech. But those are basically, I think, the primary reasons for protecting free speech. And the court, which didn't decide a First Amendment case until 1917, and since then has given substantial protection to free speech, and but with limits, and sometimes have gone even too far.
My students, and probably your students as well, I'm sure we've both had this experience, sometimes don't understand why they have to put up with racist speech or sexist speech or anti-gay speech that offends them and doesn't contribute any value to democracy. How do you feel about that?
Well, one thing they have to understand is that throughout our history, people have been unwilling to listen, and sometimes they are willing to censor speech that they don't like. And this, for example, for this generation, the lesson would be about gay rights and about the right of abortion and women's rights and the like, which would not be recognized today if it were not for the protection of the First Amendment of expression of ideas that many people disagree with and would like to silence. So being tolerant of ideas, even if you strongly disagree with them, is critical. Now, obviously, people will say that the kinds of speech that the current generation, or many of the members of the current generation, would like to suppress is evil and is stupid and is wrong, and it should not be allowed to be expressed. But that was true, for example, in World War I, when the government wanted to suppress any speech critical of the war, and they did that very effectively. And over time, people recognized, well, that criticism of the war was really important. And another example is the Civil Rights Movement, where people who were in favor of the Civil Rights Movement were deemed inappropriate and unwise and needed to be suppressed. And it took the First Amendment and the Supreme Court to basically give protection to those kinds of speakers. So what they have to recognize is that in any given instance, I may think a certain idea is wrong-headed and offensive, but if I create a doctrine or policy that allows me to suppress them, then down the road, they'll be allowed to suppress me. And that's not either good for democracy, nor is it good for one's self-interest. So the response to speech we think is wrong-headed or evil is to respond and to explain why we think it's wrong, not to silence people. Because if that becomes an acceptable norm, that will come back to haunt us in the future.
So we are obviously living at a time when there is much debate and dispute about what constitutes a fact and whether falsehoods have any value in debate and discussion. And we've seen that very dramatically over the last few years. Some thoughts about that?
Well, the Supreme Court has rightly defined false in a very narrow way. It's not disagreement with, quote, false ideas. False can only be false factual statements that can be proved to be inaccurate. And even there, the court has very much limited the circumstances in which false speech can be restricted. Defamation is one example. False commercial advertising is another example. But for the most part, the court has not allowed restrictions on speech just because it's false. The assumption is that the proper response to what we believe to be false speech is not to censor it or punish it, but to respond to it and explain why we believe it's false. And because sometimes what we believe is false may not be false. And that, that homosexuality is immoral was once believed to be clearly false. And that's partly why it was suppressed. And enough people disregarded the effort to suppress them to eventually educate people to what we believe today to be right. Now, there are other people who believe that homosexuality is bad and immoral. And the fact is they should be allowed to make those arguments as well, because if they persuade people that they're right, then that law will follow that. We don't want that to be what happens. And the way to respond to it is not to censor it, but to respond to it and to educate people to what we believe to be the right standpoint and position. So the court has allowed restrictions on false speech in the defamation context, and in the commercial context. But generally, if someone makes a false statement in either the political context generally or in just private or public debate, that's not actionable. And the reason for it is not that false statements are valuable. It's that we don't want the court or the government deciding what's false and what's true, unless it is very important. And if it's factual, not opinion. And in those areas like commercial advertising, which are only partly protected by the First Amendment, the court does allow that. But in general, if you make a statement that says, we should never have been involved in the Vietnam War, and the government wants to prosecute you for a false statement, that would be a nightmare. And that's what the court said you cannot do.
So without using the phrase, all of your answers so far have alluded to the concept of a marketplace of ideas, where we exchange ideas. Somebody speaks, and the way to deal with it if you don't like it is to speak back. That, as we know, is a concept that's about 100 years old. Does it work? Is it different in the age of social media and instant communication? Does it work better? Does it work less effectively? Do we need a new paradigm?
Well, the world of social media is obviously complicated, and we're still at the very beginning of thinking about how to deal with it. Partly because it has evolved itself dramatically over the years, and the basic assumption that courts take is that it's no different than other speech. And indeed, Congress, in enacting Section 230, has gone beyond that and said that, unlike a newspaper, which can be held liable for, say, defamatory statements that are published in the newspaper, or for obscene material that is published in a magazine or on a TV station, where the magazine or the TV station can be held liable for doing so, that social media cannot be held accountable for what other people say on it. And part of the reason for that is that newspapers, magazines, TV stations, and so on basically select what they will print or allow to be broadcast. And therefore, they are making a decision specifically to allow speech that might be regarded as not protected by the First Amendment. But with social media, in the 1990s, when Section 230 was adopted, Congress took the view that the last thing we want is to frustrate the potential value of social media, which is that you don't have some company reviewing every single post that everyone makes, because they might be held liable. That is, the company might be held liable in the way the newspaper could be, because somebody says something on Facebook or Twitter or whatever that is actionable in one way or another. Because if that was the case, then they would have to be screening everything, that billions of posts are made every day. And that would be insane. And so Congress has basically allowed social media complete freedom from responsibility for what you and I post online. Now, the individual who posts it could be held liable, just as they could if they made a speech or if they wrote an article. But basically, they said that social media is different from newspapers and so on, radio, television, magazines, because social media companies do not have the capacity to decide which posts to allow and which to strike down, because there are just too many of them for them to manage. And now the concern has become that social media has become in some way so destructive by allowing so much bad speech, however that's defined, that we need to find a way to restrict it and to limit it. And I don't think anyone's come up with a very good solution for that. I mean, one possible solution is that if someone brings to the attention of, say, Facebook, that someone has posted something which is defamatory of them, or is obscene, then Facebook has to review the complaint and decide whether or not the complaint is justified. And that's a way, a kind of intermediate way of giving the responsibility to the social media networks to review what has been posted. But short of that, the idea of saying that Facebook or any other aspect of social media is responsible for what I post right after this conversation would be crazy, because they don't have any opportunity to review it. But they do have an opportunity to review complaints. Now, that would be very burdensome because there's going to be huge numbers of complaints. But that's a potential middle ground.
The famous case of New York Times against Sullivan, the famous libel and free speech case from 1964, and you clerked for the Justice Brennan, who wrote that case. You clerked for him later. I've written about that case. You've written about that case. Is now under attack by two justices of the Supreme Court, Clarence Thomas and Neil Gorsuch, who would like it overturned. What do you think? Does New York Times versus Sullivan need to be revisited, and are they likely to gain more votes to get to that goal?
Well, if you were a pure originalist, you would say that New York Times v. Sullivan adopts a understanding of false speech that damages a person's reputation that was clearly not the understanding at the time the First Amendment was adopted. And that's clearly true. So if you're a pure originalist, you can argue this is the distortion of the First Amendment if we are limited to what was originally understood and intended it to mean. The second argument that's been made is that it has allowed too much false speech. That the concern of New York Times versus Sullivan was that, particularly with respect to speech about public officials, is that you don't want government, or including courts, to be in the business of punishing people, holding them liable for making an allegedly false speech about a candidate or a public official, because that would create a real chilling effect. That individuals would be afraid to say critical things about candidates or public officials because they wouldn't want to run the risk of being held liable if it turned out that somebody could prove their statement was false. We all make inaccurate statements lots of times and don't intend to and don't know they're inaccurate, but they turn out to be inaccurate. And in the political arena, the justice has concluded that it's very important that people be free to say what they think and to allow counter speech to be the way to address it. And that because political officials and candidates have reasonably strong access to engage in counter speech for statements that are false, then that's what their response should be. Unless the speaker was acting with what the court in Sullivan said was either reckless disregard for the truth or knowledge of falsehood. But simply making a negligently false speech statement should not be held accountable. And the idea of that was to expand dramatically the willingness and the ability of citizens to say things, particularly in the political arena, that are critical of candidates and policies and individuals and public officials. And that's a central part of what the First Amendment was about. And that holding people liable for that kind of defamation was having a significant impact on the willingness of people to say critical things about public officials. And that's damaging to the aspect of democracy that's critical. What it also does, however, frankly, is allow a lot more false speech. Even if it's not intended to be false, it allows much more false speech because many people will make statements they believe to be true that, in fact, were not true. And they may have been negligent about it. They may not have been negligent about it. But under the original common law, if you made a false statement about someone, and if the plaintiff could prove it was false, then you were held liable unless you could prove it was true, period. And it didn't matter if you believed it was true, if you were reasonable in believing it was true, and so on. So today, there's, on some quarters, a concern that New York Times and Sullivan went too far, that it allowed too much inaccurate speech that was not allowed under the common law or in the vision of the framers of the First Amendment, and that is doing harm to our democracy. And so the question is, what are the consequences of New York Times and Sullivan? On the one hand, it has greatly expanded the willingness of people to make critical statements about particularly public officials and political candidates, which is important to democracy. But on the other hand, it has enabled misleading people, either intentionally or recklessly or negligently, particularly negligently, that damage the effectiveness of democracy. My own sense is that this New York Times and Sullivan has much greater benefit than cost. It has both, as almost all decisions do. And I would certainly not overrule it or even change it, because I think although it has done some harm, it's done enormous good as well. And most of the Supreme Court decisions over time that have given significant protection to free speech do harm as well as good. So, for example, saying that you can't punish someone for criticizing government policy unless it creates a clear and present danger of grave harm means a lot of people can make statements that damage government policies that are good by turning people against them. But the Supreme, and that used to be the law. In the World War I cases, the court basically said that if you made a statement that was critical of the war or the draft, you could be punished because it might have the effect of leading some people to refuse induction into the military. And it's true that speech critical of the war might do that. And the court was terribly wrong in deciding that was sufficient to justify punishing the speech. Later, because of Justices Holmes and Brandeis, the court eventually changed its mind on this and basically said, unless the speech creates a clear and present danger of grave harm, and it was intended to create that danger, you can't suppress it. And that's analogous to New York Times and Sullivan, that overprotecting free speech is important to enable people to engage in free speech in an important way.
So one of the patterns or trends, I think, in the court in the last few years is to move away from allowing governments to treat religion and religious speech differently because of the Establishment Clause, and to now say that if you treat religious speech differently, you're discriminating against the speech on basis of the content of the speech, and that violates the Free Speech Clause. Any thoughts about that pattern or that trend?
Well, it's interesting. There are a number of cases that have arisen in which the court had both a free speech and a freedom of religion argument that it could make. The most recent one last term was the creative, what's the name again? Creative.
303 Creative.
303 Creative, right, versus Colorado. Colorado had an anti-discrimination law for employment and public businesses and so on, similar to that exists in basically every state and under federal law. And it included discrimination against on the basis of sexual orientation. And Smith, who was a website creator and created websites for lots of things, did not create them for marriages. And she did not create them for marriages, she claimed, because she did not approve of same-sex marriage. And she did not want to allow people of the same sex to use her website and have her help to create a website for their weddings in the way that she was happy to do for opposite sex couples. And so she challenged the constitutionality of the Colorado law. And it could have been decided in theory on either a religious basis to say that this law interfered with her religious beliefs by preventing her from exercising what she sincerely believed as a matter of her religion to be a violation of her religion and forcing her to engage in belief activity that was inconsistent with religion. Instead, the court focused on the free speech issue and said that you cannot compel people to engage in speech that they do not want to communicate. And this was a 6-3 decision. divided in the way often these cases are these days. And the majority, in an opinion by Justice Gorsuch, basically held that this violated her free speech rights and put aside completely her freedom of religion claim, saying that by compelling her to make websites that she did not herself want to make required her to engage in speech that she did not want to engage in, and therefore that the statute was unconstitutional. The dissenters argued that this was an anti-discrimination law that applied across the boards. It was not about compelling people to make certain statements incompatible with their speech. She had the complete freedom not to make websites if she didn't want to, but that she couldn't discriminate against gays and lesbians while giving the opportunity to, quote, straight people to use her website and have her help create the websites. And so their view is that this was an abuse of the free speech clause, because there's all sorts of circumstances in which people are compelled to engage in speech that they don't want to engage in. And there's nothing distinctive about this. And indeed, the statute was not about speech at all. It had an incidental effect here. It was about discrimination. In this case, it happened to apply to speech, but it also applies across the boards in terms of restaurants refusing to serve Black people, or universities refusing to admit gay people, and so on. And so it was only an incidental effect here. And the argument was that this is not a good enough reason to strike down the statute as applied to this situation when she had the option of just not making wedding websites.
All right, I appreciate, Jeff. I think we're out of time. Thank you for this wonderful discussion about the importance of free speech to our democracy, and I hope we'll get a chance to do this again. I appreciate your time and your insight. Thanks so much.
Thanks so much for inviting me. I appreciate your questions. I probably talked too long, but
not at all.
I'm a professor. That's what I do.
Thank you, and thanks to the Section of Civil Rights and Social Justice for the opportunity to do this broadcast.
Thank you.